A mother and father now behind bars, their 4-month-old baby dead after allegedly ingesting alcohol. According to deputies, the mother made an alarming confession, allegedly claiming whenever the baby would get fussy, the father had a fix. Not a bottle, not a lullaby, but alcohol rubbed on the infant's tiny gums. The baby's autopsy revealed an ethanol reading of 3.210. Investigators say that level is catastrophic and fatal for an infant. But it wasn't just what was inside the baby's body that shocked investigators, it was what they saw inside the home. Reportedly, no running water and roaches everywhere. I'm Kennedi Walker, and I'll walk you through a case that's as horrifying as it is heartbreaking. A West Virginia mother and father are under arrest, accused of killing their 4-month-old baby by allegedly rubbing an excessive amount of alcohol on the child's gums. According to police, Angel Talbert and James Smith welcomed a baby in July of 2024. But just 4 months later, in November, that baby was dead. Court documents obtained by Law&Crime reveal that on the morning of November 16th, Talbert told investigators she got up to use the bathroom and asked Smith to check on their baby. Smith reportedly told police that the child was lying face down, unresponsive, and not breathing. He began CPR while Talbert called 911. The infant was rushed to the hospital, but doctors were unable to save her. At the time, both parents told investigators the baby had no known health issues. She was, as they said, a healthy child. But investigators were not convinced. Documents detailed that the infant's face was discolored as if the baby had been lying face down. An autopsy was ordered and questions began mounting. Was this a tragic sudden death or was something else at play? As police searched the home, they described the living conditions as, quote, very poor. Deputies reported seeing roaches crawling throughout multiple rooms, and the house had no running water. Smith allegedly showed deputies a spigot where they would fill containers to take to the kitchen and bathroom if needed. Investigators also noted seeing a smoking device and claimed Smith admitted it was used to smoke THC. Then, months later, a critical development. In April of 2025, the state's medical examiner's office reported that ethanol was found in the child's blood with a reading of 3.210. Doctors say that level of alcohol contamination would be deadly for any child. Police questioned the parents again. At first, both reportedly denied knowing how alcohol could have entered the baby's system. But days later, that changed. Investigators say Talbert came forward with an alleged confession, telling detectives that the child's father admitted to rubbing alcohol on the baby's gums to calm her down when she became fussy. According to police, Smith allegedly told investigators both he and Talbert had been rubbing alcohol on the baby's gums together almost daily for a month. Both parents were arrested. They were charged with first-degree murder, child neglect resulting in death, and conspiracy. And joining me to talk more about this is legal expert Florina Altschuler. Florina, thank you so much for coming on today. Let's just jump right in. Could the use of home remedies like rubbing alcohol on gums be argued as generational or even cultural? And how might that impact a jury's perception?
It certainly can be argued that way, but there is no sound reason to support that, and it is not safe. In fact, it is fatal to do something like that. So, reason and common sense suggests that antiquated home therapies are not an appropriate thing to do. I think what's important here is to really evaluate the amount of alcohol that was used on this infant. And there's a significant difference between perhaps a fingertip amount, which is under no circumstances appropriate, but less likely to be fatal, versus, pouring alcohol into this infant's mouth or putting alcohol on the gums multiple times a day, every single day for who knows how many days. And so the amount of alcohol that was in this infant, in the infant's body, is going to be significant in determining just how reckless these parents were in the behavior that they engaged in.
Right. I just didn't know if it was possible. I know there's a lot of old school home remedies from years and years and years ago of people saying that, oh, I did it or my mom did it, my uncle did it and it worked. I didn't know if that could potentially be argued, especially to prove that it wasn't intentional, potentially. What do you think?
Um, well, so the question of intent, it's kind of like with drunk driving, right? Did you intend to drink the alcohol? Yes, you did. So did these parents intend to put alcohol on the infant's mouth? Yes, they did. Did they intend to purposefully kill this infant? I don't think anyone would argue that they did. But the intent is in the act, and then the act resulted in a fatality. It's just like shooting a gun. When you shoot a gun at somebody, you may not necessarily intend to kill them. Maybe you intended to scare them. Maybe you intended to hurt them. But the likelihood that you will kill them if you shoot a gun at somebody is pretty damn high. And so the question is, did you intend to do the act? Not necessarily did you intend to have that result occur. If that result is a logical and reasonable, likely to occur type of result, then it really doesn't matter whether you were too stupid to appreciate that that result would have occurred. And the, well, I didn't mean for that to happen defense doesn't work, because any reasonable person could appreciate that's likely to have happened.
Yeah, you definitely bring up a good point there. How difficult is it to prove first degree murder when alcohol is involved rather than a weapon?
So we can never really be inside somebody's mind to know what they were thinking. And so it's going to be impossible to argue this is what they meant to do unless they're outright screaming it and announcing, right? But what we could do is apply common sense to figure out what their goal or purpose was. So if we look at the purposes, the person's actions, we can figure out what they meant to do. So somebody is taking kernels of corn, putting them on a frying pan, adding oil, turning the heat on. They're not announcing that they're about to make popcorn. They're not telling us that their intent is to make popcorn, but we can logically deduce from their actions that their goal is not to make soup. Their goal is to make popcorn. And so the idea of proving intent, the burden of which is always on the prosecution, is something that can be proven by circumstantial evidence and sound, logical, common sense conclusions. Ultimately, it's a question for a jury to decide of what did they mean to do. And ultimately, it's going to be a question of what is reasonable under these circumstances. Was what they did such a gross departure from what anybody else would know to do that ultimately they're going to be held responsible anyway, because it's a foregone conclusion that that result would have occurred and they should have known.
Well, what legal strategy might a defense team pursue in this case if, like how you said, ignorance, their argument of ignorance may not hold up?
So ultimately, the best defense is exactly what you're suggesting. It's the argument of a lack of intent. It's my opinion that that defense is just not going to work. However, the defense of they didn't mean to do this, they didn't appreciate the consequences, they didn't expect for this result to occur, is the best defense available under the circumstances. Ultimately, however, while it may result in an acquittal to an intentional murder, what it's going to result in most definitely is a clear conviction on manslaughter, because the standard for manslaughter is not an intentional act to have the death occur, but a reckless act that inevitably results in the death, even if you didn't mean for it to happen. And so when an attorney chooses to argue this lack of intent, it's not going to result in a complete acquittal, the person walks away. It is very likely to result in a conviction on a manslaughter if it succeeds in an acquittal on the murder.
And I'm assuming we're looking at jail time here, even if it is manslaughter for both parents.
Oh, double digit jail time, likely in the teens. There are cases where people get sentences for manslaughter that are in the single digits in state prison. But we're talking about the death of an infant. We're talking about something that, from the facts, it is suggested continued over a lengthy period of time, was done pretty regularly by two people. I don't see how this is away with this wrist.
Is it possible that one of the parents could potentially take a deal?
Absolutely, that's always a possibility. Pretty much in every case, prosecution tends to offer at least a one-step reduction type of a deal, and that's an opportunity for the defendant to avail themselves of a plea and get a lower sentence than what they're looking at if they were found guilty at trial of the highest charge. In a case like this, it would make absolute sense. Certainly, it's up to the DA's office to make that decision. But in a case like this, where they might be looking at murder, but the facts very strongly suggest a very clear conviction on manslaughter, for them to offer a plea to a manslaughter would make sense.
Yeah, I'm just asking because, I read all the court documents, and in it, police say that when they interviewed the mom after the first or second time, she said that, oh, she had learned after the interview with police. She claimed that she had just learned that the child's father was, using alcohol on the baby's gums when the baby was fussy. But then when police interviewed the father, he allegedly told them that no, both of them knew about it. So in a case of like he said, she said, or the mom maybe saying one thing and the dad is saying no, we both knew, how could that potentially turn out in court?
It's really going to be a question of what does the jury believe. It's going to be a question of whether or not they testify, a question of which of their statements come in, right? Were they properly taken? Were they Mirandized? Were their rights read to them? And depending on what those admissions are, depending on how the evidence comes in, ultimately a jury is going to decide what they want to believe and what they don't believe.
So, according to the documents, it says that the baby had, ethanol in its system. Can you explain the difference between ethanol versus, BAC, which is blood alcohol content?
And ethanol is the alcohol product that's going to be in the system when somebody consumes alcohol. I don't know if they were using actual rubbing alcohol for it to be pure ethanol, or whether there was ethanol that resulted from them using something like, let's say, vodka. Any alcoholic substance is going to have ethanol in it. The concentration of the amount of ethanol is what will tell us whether it's a byproduct of drinking alcohol or whether it's pure rubbing alcohol. Any one of those could be a possibility, and we don't know unless we have those toxicology results in front of us.
Yeah, I was just about to ask, what role might expert testimony on infants and just alcohol toxicity play in court?
Yeah, that is going to be essential to establishing cause of death and to establish liability here for those parents. Without expert testimony to establish why this infant died, there can be no criminal case. And so an expert is going to have to testify what those ethanol levels were, what was the concentration, um, whether they're able to give an opinion, which most likely they will, as to when that ethanol was placed in this infant's system because of half-life and the body essentially eliminating alcohol from the system. We can deduce to a reasonable degree of certainty an opinion as to when that alcohol was administered. In other words, is it something that these parents gave this infant a few hours ago or a few days ago? And it would obviate a potential defense of we didn't do it, somebody else did. This infant was in the custody of a babysitter or some other adult. And so maybe that person did it because when we were with this infant during these, we couldn't have done it. So timing to be key as well. But really, it's the amount of that alcohol in the system that I think is going to be important because potentially there could be an argument by the attorney for these parents that, oh, it was just a fingertip dab just one time. Well, not if the toxicology results show that the amount that was in the infant system was clearly not just a tiny one-time dab from a fingertip. And I'm not saying that the dab from the fingertip is okay. It absolutely is not. It is well established scientifically that even a dab could be fatal. The younger that infant is, the worse it is. But certainly, the more in terms of quantity of alcohol, the worse it is.
Could the prosecution use the alleged poor living conditions to strengthen a neglect or abuse case?
I think the alleged poor living conditions are a neglect and abuse case, but these parents would be very, very lucky if all they walk away with is a conviction on a neglect or abuse charge. These parents are looking at being criminally responsible for the death of their child. And if all that can be established is that they were neglectful parents with some misdemeanor child endangerment charge, that is a gift.
Well, can you just explain, what distinguishes child neglect resulting in death from involuntary manslaughter in legal terms? Again, they're charged with more serious charges, but if they are able to at least plead it down to that manslaughter.
Well, so child endangerment is a misdemeanor charge. That is something that applies when a child does not die. We're talking about somebody who's put in a dangerous situation, but luckily there are no serious injuries. Here, what we're talking about is an infant who is deceased. And so neglect could result in that infant being deceased, but now we're not talking about a mere child endangerment charge. We're talking about manslaughter, we're talking about murder. We're talking about very, very serious charges. And a parent does not need to intentionally try to kill that child for a death to occur and for murder to apply. So imagine a scenario where a parent refuses to feed their infant child and the child starves to death. That's murder. Now, they might say, well, I didn't know, it was only a few days, I didn't think the child would die. That is not a defense. That is absolute moronic stupidity. You should have known better. If you're not feeding your child and the child is starving, they're going to die. And then you're going to be responsible for that death. And you can say, well, I didn't mean to kill the child. And arguably, maybe you didn't mean to kill that child, but you absolutely should have known that death was a very real and very likely possibility. And so the act that you engaged in is neglect. But it is neglect to such a stupidly high level that it resulted in death. And any person with any reason or common sense would be able to foresee that death is very, very likely from that action. And that's what this is. This isn't parents starving their child to death. This is parents administering a poison into a child's body, that poison being ethanol, alcohol, and that poison resulting in an infant's death. And so that is something that they should have known could happen, and it's something that they should not have done. And now they're looking at very serious criminal charges as a result.
Could prosecutors consider this a case of felony murder if neglect is proven as the underlying felony?
Uh, Yes and no. So they need to be able to prove that a qualifying felony was committed by one of the two participants, and that in the commission of that qualifying felony, a death resulted. So typically, felony murder is something that's applied in, let's say, the course of a bank robbery. Two people go in to rob a bank, and one of the two shoots and kills the teller. Well, the person who did not shoot and kill the teller is going to be responsible for felony murder, even though they didn't pull the trigger, even though they maybe didn't know that somebody was going to get killed. They thought they were just there for the robbery. But in committing the robbery and in knowing that they were there to commit a robbery, they committed a qualifying felony. A death occurred in the course of that qualifying felony, the robbery. Now they're on the hook for felony murder. This is a little bit different, and West Virginia state's laws are going to apply to answer the question of what qualifies as an underlying felony for purposes of this felony murder. I could tell you that in New York State, child endangerment is a misdemeanor and it would not qualify to result in felony murder, but you would still have the manslaughter, and you would still have um, the recklessness that resulted in the death.
Well, how might conspiracy charges be proven in a household where both parents live together and shared childcare?
Conspiracy would mean that they would need to be acting together. So one person is aiding or assisting the other person in having this result occur. So all the prosecution needs to prove is that one person knew that this was happening and didn't intervene, didn't stop. That would be sufficient for purposes of conspiracy of administering alcohol to the infant.
If convicted of first-degree murder, are parole or appeals likely in this case?
Appeals are likely with every single conviction. Anytime somebody is convicted, they're likely to appeal. There's no reason not to appeal, right? They lost. Why not try to re-argue it? In terms of parole, that's something that is going to be determined depending on what they are convicted of and what their ultimate sentence is. Many convictions, the sentencing is parole eligible. This is not the type of case where somebody would get life in prison without the possibility of parole. Those are things that are reserved for really the most extreme of murder. So think of killing a police officer or a mass murder or a hate crime fueled murder. Those types of crimes generally result in state prison time for life without the possibility of parole. All other types of crimes would be parole eligible. Doesn't mean they'll get parole, but they would be parole eligible.
How likely is it that this case will go to trial rather than end in a plea deal?
If I was the defense attorney, I think this is a good case to take a plea deal on. It has a very high sympathy level. We're talking about a deceased infant. There's not going to be a juror in this world who's not going to be sympathetic. And if there is an offer to a manslaughter to significantly reduce their state prison time exposure, I don't see how that would not be a good deal. Potentially, the deal might be worked out as well with having two parents here, where one might testify against the other. And in exchange for that person's testimony, they might get an even better deal. That is something that I see frequently. And it's just a race to the DA's office of which one wants to snitch on the other.
Well, this is a story that we will definitely be following. Florina, thank you so much for coming on today. We really appreciate it.
Sure. Thank you for having me.
The couple is being held in jail without bond. For Law and Crime, I'm Kennedi Walker.